Congress must act, and they must act now, but they have not done so. Really, in the meantime, what can we possibly do? We have to take our own actions regardless of the result of our petitions. As you can see behind me, it's Capitol Hill, and we have been talking about it. Congress must act. They must act now. And what can you possibly do? You need to call your representative. Call your representative, U.S. representative. Call your governor. Call your senators, and really try to apply pressure until we get to that result. I'm here on Capitol Hill, as you can see the building behind me, but in the meantime, what can we possibly do? We need to deal with denials. Today's video, I'll be talking about denial, okay? How to deal with denials. Do we get denials? Yes, we do. Do we get our petition? When we file our petition, do we get some of those petitions denied? Yes, of course, it's part of the process. Sometimes we get denied, but how do we act? How do we move forward? That's today's conversation. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. It is so hot, but I'm here with today's difficult topic because we have to address the problem when we see it. When we see a problem, we just go through it. How do we act? We act with dignity, we act with confidence, we act with esteem. We know that at the end of the tunnel, there is light, okay? Let's talk about petitions that get denied. The first thing, what do you possibly do? When you get a denial letter, okay? A denial letter comes through the mail, and your lawyer, perhaps, they will call you, or they will let you call them because it is a denial. But what can you do? First of all, you take a deep breath, okay? You breathe in, breathe out, and then you read it. You read it for yourself, and then you read it again at least the second time. That way you have a better perspective, what was said in the letter, and then now you can talk to somebody who's a professional to help you dissect the letter itself. But today we are going to talk about, first of all, this part one is going to be about three subjects. Remember, we have family-based immigration, we have business immigration, then we have in the middle humanitarian immigration. But I am going to go over some issues that I've seen in the past years and how I've dealt with those, so that you can have an idea when it comes to denial, what can you possibly do. If I'm closing my eyes, it's because it's so hot. I don't want to wear my glasses. Let me just put on my glasses so I can talk really fast. Okay, I have my notes here. Let's talk about marriage. When it comes to marriage, remember when somebody file a green court-based marriage, okay? And then there is a form I-130, there's a 485, 864, I-130A supplement. Well, anyway, you have the entire package, you file. So now you get a denial. Some issues, sometimes people just get a denial because it is a no-show. The petitioner doesn't want to show up. How do you deal with it? Now you have to come into the totality of circumstances. Is it a case of VAWA? Is the petitioner not showing because they don't want to go forward with this marriage because I have been abused in the marriage? Now you look into it. Is it a VAWA petition? Okay? If it's a VAWA petition, remember, Abuse, Violence Against Women Act, basically it's applied to both women and men. But when it comes to abuse, you have to look into the totality of circumstances. You can get financial abuse, you can get emotional abuse, you can get threat, repetitive threat, or physical violence, really, per se. At that point, you move in the direction of VAWA. But let's say the petitioner just doesn't want to show because he just doesn't want to show. But now it creates extreme hardship on you, on your case. Well, you can still have an argument of extreme hardship and move forward with extreme hardship on yourself because you relied on this marriage to help you position yourself. You enter into this marriage in good faith, but unfortunately it didn't end up the way you thought it was going to end up, but then it creates extreme hardship on you. At that point, you can move forward in the direction of extreme hardship. Okay? Now, let's say it's too specific and your rebuttal will be so weak. Let's say the marriage green card petition gets denied because you went to the interview with the petitioner, and then unfortunately the answer, a lot of inconsistency in the answer, and it's so specific the way the decision letter came to you. What can you possibly do? At that point, we suggest that you restart with the process, but because now you have all the elements and you know how the interview went, maybe this time around you can have a better chance. So those are just 3 issues when it comes to a marriage. There are a lot of issues, but we cannot cover all of them at case by case, basis. Okay? But let's talk about the subject of asylum. When an asylum case gets denied, most of the time the asylum will get denied because of inconsistency of evidence. What can you possibly do? At that point, while the case gets moved to an immigration judge, before the immigration judge move a proceeding, what we suggest is that you bring a lot of evidence at that point so that you can have a strong argument in court. Let's say it gets denied because you have passed the deadline. Remember, asylum must be applied within 1 year of physical presence in the U.S. But let's say it gets denied because the 1 year has already passed. What can you do? Well, the case gets removed. The case gets referred, into the removal proceeding before the immigration judge. And what can you possibly do at that point? What you will do is you will basically go ahead and make a case of exceptional circumstances. Why did you apply too late? Exceptional circumstances can be because somebody was sick, qualifying relative was sick, or sickness on yourself. Or if you don't have exceptional circumstances, maybe changes in the conditions of the country of where you're coming from, of origin. At that point too, you can make an argument in that sense. Okay, I'm outside, there's a lot of distraction, but we're going to stay focused because we really want to help out when it comes to denials. And sometimes you go in court while you make all those arguments. When it comes to asylum, it doesn't work out. You move for withholding of removal. Remember, we have talked about withholding of removal in my previous video. You can go ahead and refer back to it. And sometimes too, now you look at the backup plan. And right now the environment is so friendly that, well, if you have a child who's gonna turn 21, maybe in 2 to 3 years, you can ask for a judge really to administratively close your case so that the child can turn 21 and the child can petition for you. Or you can ask prosecutorial discretion so they can drop those charges based on certain criteria. We have talked about it. The environment is friendly now. Really, when you are in removal proceedings, you have to come up with a better strategy. Okay, that's what I'm saying. When the asylum case gets denied and you find yourself in removal proceedings, there are strategies in place that we can help you too, so that you can have a better chance before the immigration judge. And let's say that a parent petition gets denied. Parent petitions sometimes get denied because the I-130 has been really expired. What they mean by that is basically an I-130 can in fact expire when there is no movement from the time you file until the time of the interview of the green card. So if there's no movement, well, it can be basically expire and terminated and then deny of your green card. But if let's say that the result or the actions, it wasn't because of you, it was because USCIS delayed the case, well, at that point you can appeal and say, well, there was no movement, not because of me, but because USCIS has delayed the case. That's why there was no movement at all. So those are the things that you can possibly do. And sometimes waivers get denied too. Well, waiver gets denied. First of all, we have to put it into the context, right? Waivers are discretionary, and procedurally, of course, you apply for a waiver. Either you apply for it with the green card or after a green card has been denied. And sometimes when we really know that there are a lot of inadmissibility issues that will be raised with this green card petition, of course we submit the waiver up front. But again, it can be denied because of technicality. Well, at that point, what can you do? You refile it with the green card petition and wait and see how they're going to respond on that. And after that, again, there is a hold to appeal. Are you going to give up now just because one petition got denied? Of course not. You don't give up, because we are determined to dissect and know what was the reason first of the denial. That's what we do. We do case assessment. My friend, if you're interested, please don't hesitate to call my office, 202-751-2180, email on display. Well, if you call today, Sunday, my friends, nobody's going to answer you, but try to call at least tomorrow during business day. Then you have a chance for me to either call you back or email you back or text you back. Because, you know, I'm a solo practitioner, so it takes me some time to get to those voicemail and then return those phone calls. Well, Bijoux.ngwanda here. This is part 1. I'm going to move on the other direction so I can do part 2. We are, of course, going to talk about the very difficult subject, denials. When it comes to denials, my friend, it happens to anybody. It can happen to you in the immigration sector. It can happen to you in life in general. It just can happen to you. Don't feel like it's the end of the road, because the end is not the end until it is the end. Some people have taken the case until all the way to the Supreme Court, and they have found solution. Just look at Chavez and her story. 16 years later, she found the solution. So you gotta be patient with this immigration matter. It's frustrating, but there's no other alternative. But patience is required. Okay. Until next time. Bye bye.